the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files, Episode 7 with Leslie Tucker, the principal at Williams, Edelstein, and Tucker. I'm your host, Jonathan Sarr. Today, we are focusing on a fair housing claims, retaliation, and eviction. The complaint alleges that the defendants violated the Fair Housing Act by evicting the complainant in retaliation for making fair housing complaints against the defendants. Leslie, can you give us a few more details as to what allegedly happened?
Yeah, sure. This case actually has quite a lot of facts, but in general, the plaintiff is a woman who is residing at a property with her 5 children, and this property was owned by the housing authority. The dispute allegedly began when the plaintiff, the tenant, called the office to dispute or discuss a notice that she had received regarding rent. She alleges that the manager then sort of reacted rudely and hung up on her a couple of times. She, obviously considered that to be very rude and hostile, and she made a comment to another employee that she wanted to file an internal complaint against that manager. Well, seemingly, and per the complaint, right after she told that employee that she was going to make this complaint, she received a final notice of lease violation, even though she hadn't, received one previous to that. Mm-hmm. So she found that, I think these two things are related. She also alleges that at some point, right after that, she and her children were denied access to a community event. So she went ahead and submitted her internal complaint against the manager. She alleged that she and her children were being discriminated against because her children were biracial. And she basically said, I'm going to file a fair housing complaint against you with HUD. And she went ahead and did so. She did file the fair housing complaint. And, as the facts go that are alleged in the complaint, 5 days after the defendants received notice of that complaint, they issued her a notice of non-renewal. And she and her children were ultimately evicted from her unit. So kind of a lot going on there. But obviously the order and timing of all those events are very relevant.
Absolutely. Yeah, thank you for the explanation. So a couple questions help our audience understand a bit more detail. So could it be considered retaliation to take action against a resident after they've complained about anything?
No, not according to the Fair Housing Act. Just a general complaint. Let's say you're complaining about maintenance. It's taking too long to fix my stove, and I'm complaining about that. Taking action against someone because of that really is not illegal under the Fair Housing Act. What's illegal under the Fair Housing Act is to take action against someone because they have asserted their rights. They've threatened to take action against you because, of discrimination or something like that. General complaints, I think you're mean. I don't like how you run, this property. I want maintenance to, not take as long. Those kind of general complaints, it's not considered retaliation under the Fair Housing Act to take action against someone on that basis. But be aware that a lot of landlord-tenant statutes in different states do include protections against retaliating against someone for making general complaints like that. So that could be a concern from a landlord-tenant standpoint, not necessarily under the Fair Housing Act.
So, Leslie, is it a best practice not to issue notices to a resident if they have recently complained of discrimination or threatened legal action?
So it's not necessarily a best practice to, cut off all communication just because someone has alleged that you're discriminating against them, or they've threatened to sue you or threatened to file a complaint against you. That doesn't mean that you should, stop communicating with them or not issue them lease violation notices if it's warranted. But just remember that retaliation is all about timing, right? If it's challenged, if a complaint is filed, HUD or a jury or whoever is, evaluating this case, they're going to be looking at, after this person put you on notice that they are complaining about something illegal that they think you're doing, did you take some kind of action soon after you received that complaint or you received that notice? How soon after receiving that notice did you issue this lease violation notice, or whatever the adverse action happens to be? So they're going to be looking at the order in which things happened. If you receive a complaint or a notice that someone's going to file a suit, lawsuit against you or something like that, if then thereafter they don't pay their rent or they violate their lease in some way, yes, you can still issue them a lease violation notice because you are just enforcing your lease. But it's also really, really important that you are aware that this could be reviewed as retaliation, and to make sure that you are fully and thoroughly documenting everything that happens after that, because you're going to need to defend yourself if they do, in fact, allege that you are retaliating against them. So make sure that you have a good basis for any action that you take. Everything is well documented, and that you are keeping a good file just in case you do need to, defend yourself.
Okay, very good. So thank you for that explanation. We appreciate you reviewing these case files with us. And thank you, everyone, for tuning in to our show. Until next time, take care, everyone.